If you're an employer who is being sued for any type of employment law violation in California, it is very important that when you have that initial discussion with your attorney about your potential defense and your defense strategy, it is very important that you not only talk about the legal aspects of the case, but you also talk about all the practical considerations. You simply cannot look at your case in a legal vacuum, so to speak. You simply cannot look just at the evidence that helps the employee to prove his or her case against you, or look just at the evidence that helps you defend your case. You also have to look at the other factors. You have to look at your budget. You have to look at the plans that you have for your company. You have to look at whether or not you are planning to merge, to sell your company, or to buy some other company. You have to look at your other obligations. Do you have big expenses coming up? Do you have other claims? Are you raising money, and do you have to make a very good impression on potential investors by not having any pending claims? You should be asking your attorney the following questions very openly and very honestly. What is my worst case scenario here? What will happen if I lose? How much am I likely to have to be paying to you and to the other side? What is my best case scenario? If I win, meaning if the case is dismissed, or if we go to trial and the employee is not awarded anything, how much am I still going to spend on attorney's fees and costs? Given the claims that are brought against you, and given the amount of money that maybe the employee is asking in their lawsuit or in their administrative claim and their wage claim, what is the better way to start your defense? Is it better to reach out to the other side and make maybe a modest settlement offer early and to test the waters and to see what the other side is going to say? Or is it better to send a very strong message that you're not planning to pay anytime soon, at least until a lot of work has been done, and you're not planning to make any offers whatsoever until way later in the case? Well, the answer to these types of questions will depend on a lot of things. It will depend on the size of your business, your budget, the other things that are going on in your life as a CEO or as a manager of the company, and in the life of your business. This will also depend on the nature of the claims that are brought against you, and also on the type of attorney that's on the other side that represents the employee. You have to talk about all these things with your attorney before you come up with a defense strategy. Saying what's right and what's wrong and simply dismissing the allegations made by the employee and saying, you know what, he's completely wrong, he's lying, I'm telling you the truth, he doesn't have a case, I didn't discriminate, I didn't retaliate, I didn't wrongfully terminate anyone, I paid everyone what they're due, I complied with all the laws. It's very easy to say that, but you have to look at the reality, at the practical reality, and at the financial reality that you will be facing when dealing with that type of case. The right attorney, an experienced employment attorney, should be able to talk to you about all these aspects. That attorney should be able to put himself in your shoes and honestly tell you what he would do in your situation, in your case, after he gathers all the important information in order to give you that answer and in order to give you that advice. Thank you.